Deputy Public Defender for Los Angeles County, Philip Dube. And Philip, all right, let's start with Rotrell Cameron. How do you think he fared as far as being a state's witness? We'll talk about his attire in just a minute, but first off, his testimony.
No, I actually found him to be somewhat credible. You know, it looked like he really had no dog in the fight. There was really nothing in it for him. In fact, it looked like he didn't even want to be there, frankly. He was just what I call a fact witness, a percipient witness, and basically testified to what he perceived. It's up to a jury to decide what weight to give it.
All right, so basically you saw him there in his orange jumpsuit. He had his shackles on, his handcuffs on there. Again, that was because of a material witness warrant, because they were having trouble getting him to agree to come in and testify. He was talking about the fact that it's not that he didn't want to testify, he just had other things, other responsibilities, so it became an issue. What do you think about pulling him in on a warrant that requires him to be in court in an orange jumpsuit and handcuffs?
Well, I got to tell you, you know, a subpoena or a court order is not a save the date. It's not an invitation. You know, it's an order to appear. And if you fail to appear, there are very coercive measures in place to secure your appearance and your presence in court. And in this particular case, they picked him up. You know, Michael, years ago, I needed a priest one time in a drug case. You know, the client was a congregant at a nearby priest in South LA, and that priest didn't show up. Well, let me tell you, a body attachment went out, and the next day he was in the lockup with his collar and his, you know, his priest garb, etc., and was forced to testify. So yes, if you need the testimony, you need the testimony. And even after going through all those machinations, my client was still convicted, if you can believe it. So even though the state's going through all this trouble to get this witness in, doesn't mean that he's going to save the day and score a conviction for the prosecution.
Absolutely. I mean, he gave testimony that I thought went both ways. One of the interesting things he talked about was, and you mentioned this earlier, you know, the victim in this case, he says, got out of the car, ran after him. He even talks about it on the 911 call as well as in court, that he thought the car actually ran the bike off the road. So that's what we touched on when we were talking a little earlier. But then he says the guy squatted down in front of him and that he was backed into a corner. That's Edgecombe, the defendant in this case. So who does that testimony help?
Kind of cuts both ways. Yeah. You know, again, at this point, I don't think there's any evidence that the victim, the decedent, had a weapon. So again, what you have so far maybe is a pushing match, a fist fight. If both sides are, or both parties are, you know, trained in the martial arts, maybe one can do judo, one can do karate, whatever it might be. But so far, you know, it's an unfair fight if only one has a firearm. And that would be an unlawful use of excessive force for purposes of self-defense.
Now, we know that the defense is going to be calling a use of force expert that's probably going to be testifying about the perception of that situation. But what's interesting is when you start adding up the pieces, and I think this is how the defense is going at it, when you have the car running him off the road, you have the guy getting out of the car while the car is still moving, running up to him and then squaring up. It's really going to come down to, in my estimation, that moment. Is it going to be reasonable? This jury is going to think it's reasonable for Theodore Edgecombe to believe that he was under some sort of deadly threat. Because that, if my understanding is correct, Philip, would be the only way that he would be allowed to pull a gun and shoot under those circumstances.
That's absolutely correct. And again, if he was in fear that the car itself was going to be the weapon to take him out, or that somebody in the car was in fact going to be a shooter or, you know, an assailant, then he should have used deadly force or whatever type of reasonable force was necessary under the circumstances aimed toward the car. But not against Mr. Clearman, because clearly what you have is somebody coming on foot without any obvious weapon in the hand to have a man-to-man, one-on-one conversation. And you don't get to have the upper hand by taking out your gun and blasting him in the face. That's called murder.
Yeah, and what's interesting is, too, I think what's important here for me is not only the closeness of the defendant, which I think helps the defense, the closeness of the victim, excuse me, but the amount of time, because it sounds like the guy squared up with him and then almost immediately, without any kind of, you know, anything at all, any talking or anything, he seems to pull the gun and shoot. And I think that time is going to be an issue for the defense as well.
Absolutely. And let's just pretend hypothetically that Mr. Clearman was a cop that he was just a cop wanting to talk to Mr. Edgecombe, and he's approaching him. Does Mr. Edgecombe, because the cop might have a weapon, get to shoot that cop in the face? Does he get to fire at him merely because somebody wants to talk to him after he has sucker punched somebody? No, it is unreasonable. Now, to be fair, under Wisconsin law, he might be entitled to what we call the imperfect self-defense, meaning he may have had an honest belief, in other words, subjectively, in his own mind, for the need to use self-divorce, but objectively, looking back as an objective party, it was unreasonable. And what the imperfect self-defense could get him, perhaps, is a second degree or a manslaughter under Wisconsin law, which beats life without parole.
Yeah, an imperfect self-defense is available in Wisconsin. So is stand your ground. He does not have to retreat. He does not have to move away from this guy. So how does that play into the jury's, the way they look at this information?
Well, no. So again, if Mr. Clearman, in fact, did have a gun, Mr. Edgecombe would not have to turn around like a little scaredy cat and run off to try to, save his life. He can, in fact, just do that, stand his ground, pull the gun out and blast him to save his life. The law does not require in Wisconsin that you do that you try to avoid the confrontation and take off and do whatever you can to minimize carnage. It just does not require that. You can actually face force with force, and whoever's quicker on the draw hopefully will survive. But unfortunately, that was not the fact pattern here. He was not meeting deadly force. He was meeting some type of confrontation, some kind of force. We don't know what that was. And he may have crossed the line into that unlawful homicide.
Yeah, that's the question, of course, where this jury of 12 women, 5 of 7 appear to be African American, 7 appear to be persons of color. They will have to figure out those very questions. All right, Philip, stand by. We're going to take a break now. When we come back today, the jury in the